Welcome to Class Actions Symposium, and you are from Case Pilot.
That's correct, yeah.
Now, it's a name that a lot of people have heard. We may not exactly know what you do, so the elevator pitch, go.
I'm pleased to hear that the name's heard. That's always a good sign. Bear in mind we're sort of only 6 years old.
Yeah.
We are a claims administrator, but we're pretty unique in the claims administrator space, being the only UK born and bred UK administrator. Personally, I've got a lot of experience of administration of cases outside of Europe, of the UK, but into Europe. We do a hybrid of opt-in and opt-out work as well, which again is quite unique. We provide a lot of wraparound litigation support services like outsourced claimant communications departments as well. So in a nutshell, that's us. I'm not sure if that was an elevator pitch or a bit longer, but we're there.
Well, it was a long elevator ride.
Yeah.
We maybe got
all the way to the top and down again.
Yeah, absolutely. So it's interesting that when people think of class actions, the back office stuff, I suppose, is at the bottom of everybody's list. But of course, I'm guessing that it couldn't really function without people like yourselves. So are your clients the lawyers, the class representatives, anyone who will have you?
Well, not quite the latter. Predominantly our clients are law firms. They're the ones that will approach us. They're the ones that we will talk to about new proposals. They're the ones that we will work through what the actual plans and strategy are going to look like. We have a close interaction with class reps, especially in the UK. We're the appointed administrator on 5 of the CAT claims at the moment, and we work incredibly closely with the class reps. On various occasions, we're retained directly by them as well. And increasingly, we're finding that although they're not our clients, they're becoming a good referrer of work is the funding market. So the nature of the beast is such that there is not a case we work on that hasn't got funding sitting behind it. It has to have, or any collective action has to have that. And as a result of that, we have good relationships with a lot of the funders who are mostly in London, and they will quite often come to us and say, there's a firm talking to us about this particular case. We think it's interesting. We're looking at taking it up, but we think that there's the back office element of it needs to be thought out.
Yeah, that's interesting because you have preempted a question I was going to ask you, which is about third-party funding. Traditionally, a lawsuit was between the claimant and the defendant. And now we have, especially with class actions, because there's pretty much no other way to do it, we have third-party funders, so we have a third party involved. And then with organisations like yours involved, we have a fourth party involved. And I'm wondering whether there's any danger of either impinging on the client-lawyer relationship, perhaps not so much from yourselves, but from third-party funders, just sort of muddy the waters, because of course they're there to make a return on investment. I'm sure they want to see justice done as well, but they are ultimately an investment company, not a law firm. So I'm wondering if you think there's any dangers with third-party funders coming into the landscape.
Sure, because there can be a perception sometimes that perhaps all of those stakeholders don't, at every point of the process, have their interests great aligned, which is understandable. I think that there's also, beyond that wider, there's a wider net of stakeholders in these cases than you've outlined. Of course, there's the lawyers, there's the claims administrator, there's the litigation funders, there's the class reps themselves who are actively engaged. Sure. If you look at the cases in the Netherlands, you've got these foundations, SPVs, that are set up to win these claims. They have their own panel, they have their own management board, they have their own supervisory board who will also get involved. You have the experts on the case who get thrown into the mix as well, be it the economists or those that do the financial modelling. And then you have, like we've heard from the last panel, you have payments providers, you have the panel before that we're talking about Broadbridge, we're talking about how they do monitoring of claims, etc. So there's lots of stakeholders in these kind of cases. My personal opinion, I guess it has to be, is that enriches the experience. I think that having that team of very multidisciplined professionals who all will be looking at it from different angles means that that there are far more voices at the table, which in itself can be quite complex, but far more voices to have a lively discussion about what is the correct way
So it
forward.
could actually be a positive thing.
I think it can, and it can move away from it being purely a legal process. Because in collective actions, there's a lot outside of that legal process. Ultimately, the claimants, that's definitely where we fit in. Is thinking about the claimants and what their position is in all of this, and how to speak to them, and how to make sure that their interests are best protected.
Yeah. And finally, you just mentioned the panels we've heard before this morning, and much of that has been comparing the very mature, established landscape in the US as opposed to the burgeoning systems we have in the UK and in the EU, and then the differences within the EU, civil jurisdictions compared with common law jurisdictions. But looking at the US and you being the only UK-based organisation doing what you do, what can we learn from them, both in a positive way to emulate and in a negative way to say to ourselves, well, we're definitely not going to go down that route?
Yeah, I mean, there is a lot to learn, right? They are established regimes. The US, Canada and Australia have very established class action regimes. I've practiced in the US. I've lived in the US and worked on administrations out there. So there is a lot to learn, and we don't want to completely reinvent the wheel, right? But what it gives us the real opportunity is to be creative and innovative in developing processes that take on board the learnings from other jurisdictions, but build something that's really fit for purpose. And that fit for purpose means that it's sensitive to the cultural requirements of the class. It's modern day as well. We've talked about digital payments versus checks. People just don't want checks nowadays. So I think that it's as someone practicing in the space, it's immensely interesting at the moment, and challenging and rewarding in equal measure. But I think that we can learn, and we can take on board those learnings, and we can, there's a real opportunity to build something quite trailblazing and formidable for these kind of cases, both within the UK and Europe.
That's brilliant. Claire, thank you so much for joining us.
Thank you.